All right, welcome back to the Daily Facts, and we're just going to get right into it where we left off with the General Flynn court case. Okay, nor was anything said on the calls themselves to indicate an inappropriate relationship between Mr. Flynn and a foreign power. Indeed, Mr. Flynn's request that Russia avoid escalating tensions in response to U.S. sanctions in an effort to mollify geopolitical tensions was consistent with him advocating for, not against, the interests of the United States. At bottom, the arm's length communications gave no indication that Mr. Flynn was being directed and controlled by the Russian Federation, much less in a manner that threatened national security. Okay, they provided no factual basis for positioning that Mr. Flynn had violated FARA, nor did the calls remotely transform Mr. Flynn into a viable candidate as part of the larger umbrella case into Russian interference in the 2016 presidential election. In any event, there was no question at the FBI as to the content of the calls. The FBI had in its possession word for word transcripts of the actual communications between Mr. Flynn and Mr. Kislyak. With no dispute as to what was in fact said, there was no factual basis for the predication of a new counterintelligence investigation. Nor was there justification or need to interview Mr. Flynn as to his own personal recollections of what had been said. Whatever gaps in his memory Mr. Flynn might or might not reveal upon an interview regurgitating the content of those calls would not have implicated legitimate counterintelligence interests or somehow exposed Mr. Flynn as beholden to Russia. Notably, at the same time, FBI did not open a criminal investigation based on Mr. Flynn's calls with Mr. Kislyak, predicated on the Logan Act. The FBI never attempted to open a new investigation of Mr. Flynn on these grounds. Mr. Flynn's communications with the Russian ambassador implicated no crime. This is apparent from the FBI's rush to revive its old investigation rather than open and justify a new one. See example 7 at 1-2, as well as its ongoing inability to espouse a consistent justification for its probe and conversations with DOJ leadership. In fact, Deputy Attorney General Yates thought that the FBI leadership morphed between describing the investigation into Mr. Flynn as a counterintelligence or a criminal investigation. In short, Mr. Flynn's calls with the Russian ambassador, the only new information to arise since the FBI's decision to close out his investigation, did not constitute an articulable factual basis to open any counterintelligence investigation or criminal investigation. Mr. Strzok and Ms. Page apparently celebrated the serendipitous and amazing fact of the FBI's delay in formally closing out the counterintelligence investigation. Having the ability to bootstrap the calls with Mr. Kislyak onto the existing authorization obviated the need for the seventh floor of the FBI to predicate further investigative efforts. In doing so, the FBI sidestepped modest but critical protection that constrains the investigation reach of law enforcement, the predication threshold for investigating American citizens. All right, let's go back and read this. Congress first enacted the Logan Act in 1799 to guard by law against the interference of individuals with the negotiation of our executive with the governments of foreign countries. Joseph Gates and William Seaton, Annals of the Congress of the United States, 2494. 1851, quoting 5th Congress 3D session. See also Waldron versus British Petro Company, 231 F Sup, 7289 in 30 SDNY 1964. The Department of Justice did not appear to have brought a prosecution under the statute in the department's 150-year history, and the government is aware of only 2 indictments in 1803 and in 1852, neither of which resulted in a conviction. In the absence of any history of enforcement or any public guidance concerning the scope of its prohibition, the department does not believe there was a legitimate basis to investigate and prosecute the designated National Security Advisor of the President-elect under the Logan Act for communicating with a foreign ambassador and seeking to mollify geopolitical tensions in advance of the inauguration of the next president. All right, let's continue. Nor did anything about the statements by Vice President Pence or Sean Spicer in mid-January, weeks after the FBI had resolved to resurrect its dormant investigation into Mr. Flynn, provide a separate or distinct basis for an investigation. Had the FBI been deeply concerned about the disparities between what they knew had been said on the calls and the representations of Vice President Pence or Mr. Spicer, it would have sought to speak with them directly, but did not. Whether or not Mr. Flynn had been entirely candid with the future Vice President or President Secretary did not create a predicate for believing he had committed a crime or was beholden to a foreign power. The frail and shifting justifications for its ongoing probe of Mr. Flynn, as well as the irregular procedure that preceded his interview, suggests that the FBI was eager to interview Mr. Flynn irrespective of any underlying investigation. As it is undisputed, the agents breached the common practice of arranging for the interview through the White House counsel. Deputy Director McCabe effectively discouraged Mr. Flynn from procuring counsel or even notifying the White House counsel. The interviewing agents failed to issue the Common Section 1001 admonitions about lying to investigators. Nor did the FBI even notify Acting Attorney General Yates that the interview was happening until the interviewing agents were already en route to Mr. Flynn. This gambit by the FBI left Yates flabbergasted and dumbfounded, and those 2 words are in quotes. Additionally, prior to the interview, there were internal FBI discussions about whether to show Mr. Flynn the transcripts of his call with Mr. Kislyak. In light of the fact that the FBI already had these transcripts in its possession, Mr. Flynn's answers would have shed no light on whether and what he communicated with Mr. Kislyak. And those issues were immaterial to no longer justifiably predicated counterintelligence investigation. Similarly, whether Mr. Flynn did or did not recall communications already known by the FBI was assuredly not material. Under these circumstances, the government cannot explain, much less prove to a jury beyond a reasonable doubt, how false statements are material to an investigation that, as explained above, seems to have been undertaken only to elicit those very false statements and thereby criminalize Mr. Flynn. Although it does not matter that the FBI knew the truth and therefore was not deceived by Mr. Flynn's statements, a false statement must still be capable of influencing any agency function or decision. Even if he told the truth, Mr. Flynn's statements could not have conceivably influenced an investigation that had neither a legitimate counterintelligence nor criminal purpose. Okay, see United States versus MINUSCO. Neither the answer he in fact gave nor the truth he allegedly concealed could have impeded or furthered the investigation, right? So that's United States versus Hansen, 772 F2D 940 949 DC circa 1985, noting that a lie can be material absent an existing investigation, so long as it might influence E, the possibility that an investigation might commence. Let's just go back here real quick and read this. Pre-STAP's talking points prepared in advance of January 24 morning meeting with McCabe reflect this internal debate. And that was 5. All right, accordingly, a review of the facts and circumstances of this case, including newly discovered and disclosed information, indicates that Mr. Flynn's statements were never material to any FBI investigation. And even if they could be material, the government does not believe it could prove that Mr. Flynn knowingly and willingly made a false statement beyond a reasonable doubt. Based on the facts of this case, the government is not persuaded that it could show that Mr. Flynn committed a false statement under its burden of proof. The FBI agents had the impression that Flynn was not lying or did not think he was lying. And the statements in question were not, by their nature, easily falsifiable. In this interview, Mr. Flynn offered either equivocal, "I don't know," or indirect responses, or claimed to not remember the matter in question. All right, so we're going to read these here, 6 and 7. So it refers to this one, accordingly, a review of the facts and circumstances, so on and so forth. So this is 6. And let's locate 7. And 7 is here. Okay, so let's read these. The statements by Mr. Flynn also were not material to the umbrella investigation of Crossfire Hurricane, which focused on the Trump campaign and its possible coordination with Russian officials to interfere with the 2016 presidential election back prior to November 2016. Mr. Flynn had never been identified by that investigation and had been deemed no longer a viable candidate for it. Most importantly, his interview had nothing to do with this subject matter, and nothing in FBI materials suggests any relationship between the interview and the umbrella investigation. Rather, throughout the period before the interview, the FBI consistently justified the interview of Flynn based on its no longer justifiably predicated counterintelligence investigation of him alone. And 7, the government appreciates that the court previously deemed Mr. Flynn's statements sufficiently material to the investigation. It did so, however, based on the government's prior understanding of the nature of the investigation, before new disclosures crystallized the lack of a legitimate investigative basis for the interview of Mr. Flynn, and in the context of a decision on multiple defense Brady motions independent of the government's assessment of its burden of proof beyond a reasonable doubt. All right, let's continue. Combining the vague substance of the answers, the FBI's own preliminary estimation of Mr. Flynn's truthfulness, the inconsistent FBI records as to the actual questions and statements made, and Director Comey's own sentiment that the case was a close one, the evidentiary problems that have emerged create reasonable doubt as to whether Mr. Flynn knowingly and willingly lied to investigators during the interview. Mr. Flynn previously pleaded guilty to making false statements. See the defendant's plea agreement, ECF numbers 3 through 4. In the government's assessment, however, he did so without full awareness of the circumstances of the newly discovered, disclosed, or declassified information as to the FBI's investigation of him. Mr. Flynn stipulated to the essential element of materiality without cause to dispute it insofar as it concerned not the course of conduct, but rather that of the agency investigating him, and insofar as it has been further illuminated by new information and discovery. The advocacy function of a prosecutor includes seeking exoneration and confessing error to correct an erroneous conviction. That's Warney versus Monroe City. So in the final analysis, irrespective of Mr. Flynn's plea, prosecutors have a duty to justice. That makes sense. Federal prosecutors possess immense power to strike at citizens, not with mere individual strength, but with all the force of government itself. Howard Jackson, the federal prosecutor, 24, Judicature, 1818, okay, and so on and so forth. For that reason, the citizen safety lies in the prosecutor who seeks truth and not victims, who serves the law and not factional purposes, and who approaches the task with humility. Based on a careful assessment of the balance of proof, the equities, and the federal interests served by continued prosecution of false statements that were not material to any bona fide investigation, the government has concluded that the evidence is insufficient to prove its case beyond a reasonable doubt. The government therefore moves to dismiss the criminal information under Rule 48A. Conclusion, again, the government respectfully moves under 48A to dismiss the criminal information against Mr. Flynn. All right, respectfully submitted, Timothy Shea, United States Attorney, DC Bar number 472845. All right, that concludes that. Now let's take a look at some of the main facts of this Flynn case. All right, so the facts from the Flynn court case. The FBI opened a counterintelligence investigation into Mr. Flynn on August 16, 2016, as part of the larger Crossfire Hurricane umbrella. Vice President-elect Mike Pence stated in a news interview that Mr. Flynn had suggested that his conversation with Kislyak did not relate to sanctions. On January 4, 2017, FBI Deputy Assistant Director Peter Strzok learned that Razor's closure had not been timely executed, and the counterintelligence investigation into Mr. Flynn was unexpectedly still formally open. Mr. Strzok immediately relayed the serendipitously good news to Lisa Page, the special counsel to FBI Deputy Director Andrew McCabe, remarking that our utter incompetence actually helps us. FBI Director Comey took the position that the FBI would not notify the incoming Trump administration of the Flynn-Kislyak communications. Deputy Attorney General Sally Yates and other senior DOJ officials took the contrary view and believed that the incoming administration should be notified. In advance of the interview, Director Comey determined that they would go interview Mr. Flynn the following day without notifying either DOJ or the White House. After the interview, the FBI agents expressed uncertainty as to whether Mr. Flynn had lied. FBI agents reported to their leadership that Mr. Flynn exhibited a very sure demeanor and did not give any indicators of deception. The calls were entirely appropriate on their face. Mr. Flynn has never disputed that the calls were made. Indeed, Mr. Flynn, as the former director of a defense intelligence agency, would have readily expected that the FBI had known of the calls. And the conclusion, the government respectfully moves under Rule 48A to dismiss the criminal information against Mr. Flynn. And that concludes the review of this court case of General Michael Flynn. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below, and we'll talk again soon. Bye.